Good evening. Thank you for joining us for Essential Planning in Uncertain Times. My name is Travis Gasper. So glad everybody could be here tonight. Some brief housekeeping before we begin. First of all, this webinar is being recorded, and please silence your phones and close distractions such as any social media. We really want you to take this time to focus and deserve this time for yourself. Really focus on the people who matter most and the reason you're here tonight. Again, my name is Travis Gasper. I'm an estate planning attorney and the founder of Gasper Law PLLC. We are a boutique estate planning firm in Dallas, and we help individuals and families throughout the state of Texas. Here's all my contact information. Please feel free to reach out to me if you have any questions after the webinar. So why are you here tonight? Well, I won't put anyone on the spot, but you are in the right place if you are here tonight to gain peace of mind, or you want to protect your family and assets, or you're looking to take control of your future. Or maybe you're here because you really have no idea where to start when it comes to estate planning, and that's okay. Whatever the reason, I promise you, you're in the right place, and this is going to be a great use of your time. Here's what we're going to cover in the time we have. First, I'll talk about the risks of doing nothing, which is an option for everyone. And we know from surveys that that's where many of our family and friends are right now. And that may be where some of you that are watching are. Only about 30% of Americans have an estate plan in place at all. So we'll talk about what that means, doing nothing, and you can decide if you're okay with that. Next, I'll address some common misconceptions about estate planning in general. I'm guessing some of these may sound familiar to you, but that's okay because we are going to address those and debunk them right now tonight. Then I'll go over key documents that all of us need, regardless of age, wealth, and provide some real life examples and how they apply and how these documents can really put us in control of our future to protect us and the people that we love. Finally, we'll leave some time for question and answers. So go ahead and start thinking now of questions you may have, and then click the Q&A icon. And at the end of the webinar, I'll try to answer as many questions as possible. Oh, one more thing. Before we wrap up tonight, be sure to stick with me for the whole webinar because we have a special gift for each of you that I don't want you to miss out on. It's valued at $450, and that'll come at the end of the webinar. So please stay tuned for that. I promise it'll be worth it. All right, let's jump right in. So dying without a will or a trust is called dying intestate. And this may be the situation that many of you are in right now. This is the doing nothing scenario. And it means that your assets are distributed according to state law and that they could go to people that you don't want them to go to. That means that your kids will get their inheritance at age 18 and outright. And they could end up losing that money that you've worked so hard on for in a divorce or spend it unwisely. Your spouse could remarry after your death and leave the hard-earned money that you worked so hard for to a new spouse and kids. It also means that a judge will decide who raises your minor children and who's in control of your children's money. And the other risk of doing nothing is that it means probate court is guaranteed. If you're okay with this default plan, as I've laid out, then you don't need to do any estate planning. But I've yet to meet someone who actually wants anything on this list to actually happen. I want to speak to the parents today who have minor children. If you have minor children, that is kids below the age of 18, one of your top priorities is getting in writing who you want raising your children should something happen to you and your spouse or partner. In fact, I think parents of minor children need planning more than anyone, even people who are older, because there's nothing more important than making sure your kids are taken care of by the people you want, the way you want, no matter what. So at a minimum, parents should have a basic will, because a will is where you name your choice of guardians, who you want to take care of your kids. So what happens if you pass away and you haven't named guardians in a will? A judge is going to decide who gets custody of your children. Here's some common reasons we hear for why people think they don't need to plan ahead. See if any of this sounds familiar. First, they think they're too young to need estate planning, that it's only necessary for older adults. Second, we hear that estate planning is only for people with a lot of money. And finally, if you're lucky enough, like me, to have an amazing spouse, some people think, oh, my spouse will just handle everything. All right, those three myths. So let's debunk them one by one. Number one. Myth number one, I'm too young. Well, you may think that now, but trust me, it goes fast. And one day you'll wake up and you're almost 40. But the truth is life is unpredictable and unexpected events can happen at any age. And young people are actually more likely to be involved in accidents that could leave them incapacitated or disabled. If you're a parent or pet owner out there, so if you have minor children or pets, estate planning should be non-negotiable. You want to designate guardians or caretakers in case something unexpected happens. And if a younger person wants to involve family or close friends in their healthcare decisions, then documents like a HIPAA authorization allows them to share medical information with designated individuals. These are all reasons that even if you think you're too young, that estate planning is for you and something that is really crucial and necessary. Myth number one. Myth number two, I'm not wealthy enough. First, most clients say this, even those who have considerable assets. But if this sounds like you, consider it's not just about money, it's about decisions. Estate planning allows you to decide who will make financial or medical decisions for you if you're incapacitated. That includes who will care for your children or pets if something happens to you, and how your possessions, no matter how big or small, will be distributed. If you're in the hospital or incapacitated, perhaps only for a short period of time, you are going to need someone to help manage your income, benefits, and expenses. And even with limited assets, family members often play a crucial role in providing support during a health crisis. Again, a HIPAA authorization allows you to share medical information with trusted family members and friends. And everyone, regardless of income, should make sure their wishes about life-sustaining treatment are discussed and honored. And you do that with an advance directive, also known or referred to as a living will. Myth number three, my spouse will handle everything. Well, here's the fact. Without proper estate planning, your spouse may not have the authority to manage everything. Here's why. First, joint accounts are not enough. While your spouse may have access to joint bank accounts, this doesn't apply to accounts or property solely in your name. Without documents like a durable financial power of attorney, your spouse could face delays or even court intervention to access or manage those assets. Second, healthcare decisions could be complicated. If you become incapacitated, your spouse doesn't necessarily automatically have the right to make medical decisions for you. Without a medical power of attorney in place, they could face legal hurdles when trying to advocate for your care. Number three, state laws could create challenges. If you pass away without a will, State intestacy laws determine who inherits your assets. In many states, this means your children, if you have them, may share the inheritance with your spouse. You can imagine how this could create unnecessary financial stress or conflict. And fourth, guardianship for minor children. If you and your spouse have young children, again, who will take care of them if something happens to both of you? Relying on the assumption that my spouse will be there leaves an important gap if you're not prepared. Here's the thing. The time is now, not after you are unable to make these decisions for yourself. I know this can be difficult to hear, and these are not decisions that anyone takes lightly, and we all hope that we have all the time in the world to make them, and that the documents and decisions that we help clients make are ones that they only have to use, much later in life. But I think we all know stories and have had personal experiences with friends and family members where that's not the case. And sadly, sometimes it can be too late. So I know this can be difficult to hear, but the good news is you have the ability to put all this into place for yourself, so you never have to go through some of the very difficult and sad real life examples that we are all too familiar with. So here's what you can do to protect yourself and your family. There are 4 documents that we're going to go over that are absolutely essential. And I went with baby graphics tonight because I know that some of the people watching may not have kids, but I thought this was better than looking at stock footage of adults, and just something to bring a little levity to what's been a pretty heavy start to the year and a heavy few weeks. So hopefully if you're watching out there, you are enjoying some cute kids, if nothing else. Okay, the 4 documents that are essential. First, a financial power of attorney, which in Texas we call a statutory durable power of attorney. Second, a medical power of attorney. Third, an advance directive, also referred to as a living will. And fourth, a HIPAA authorization. Let's take a look at those one by one and kind of break that down. A financial power of attorney designates someone you trust to handle your finances if you're unable to, whether that's because of disability or incapacity. It's there to prevent financial chaos and ensure your bills are paid, investments are managed, and so on. It can also allow a person that you trust to sell property, manage your business, care for your pets, fund a trust, and access your mail. Without a financial power of attorney, if you become incapacitated, no one will have the legal authority to manage your finances, including paying your bills, managing your investments, or accessing your bank accounts. Your family may have to go through a court process to appoint a guardian or conservator, which can be expensive, time-consuming, not to mention emotionally draining. If that happens, a judge would decide who handles your financial matters, which might not align with your preferences or the person you trust. So here's an example. You're in an accident and unable to make decisions. Your spouse goes to the bank to pay your mortgage, but is denied access to your account because it's in your name only. They'd have to go to court and petition the court for access. And if we all know a thing or two about courts, that could potentially lead to missed payments and financial strain. I know we always think about, worst case scenarios when we talk about incapacity and, disability and these situations where you'd be unable to make decisions for yourself or pay your bills. But a lot of times what people face and, what all of us may face in the future is just a temporary incapacity where we're unable to do these things for a short period of time because of accident, or illness. So consider, what would happen if you were a few days late on mortgage or rent and didn't have somebody that could make those decisions for you. If your landlord or mortgage company, how understanding and forgiving they would be, or what that would do to your credit score. Things to think about. A medical power of attorney ensures your healthcare wishes are respected, even when you can't communicate them, by authorizing someone you trust to make medical decisions. Without a medical power of attorney, doctors and hospitals may turn to state law to determine who makes your medical decisions, which may result in someone you wouldn't choose being in charge. Then family members may disagree about your care, and that can lead to conflicts, delays in treatment, or even legal battles. Here's an example. You're unconscious after a stroke, and the doctors need someone to make decisions about your treatment. Without a medical power of attorney, your estranged sibling may end up in charge of your care instead of a trusted partner or a good friend that you really trust and want to be there making those decisions, creating stress and complications for everyone involved. This is an important point that I emphasize with clients and friends really who are single or maybe in long-term relationships but not legally married. It's so important to get these wishes down in writing in a legally valid and enforceable document, just for these hopefully remote situations that may come up, because if not, there is the default plan and the default decision makers that doctors and hospitals would look to make decisions in that case. And in those situations, it may be parents who you may not want to be making those decisions for you, or siblings, adult siblings, who would be making those decisions versus the people that person that you shared your life with. And just because you don't have a marriage license or haven't legally codified or solidified that relationship, it may not be valid and recognized by healthcare providers. So a medical power of attorney can give you control over that and make sure that you are protected and the person that you love and trust is by your side making those decisions when you need it the most. An advance directive, also sometimes called a living will, states your wishes about withdrawing or withholding life-sustaining procedures if your condition is terminal or irreversible and death is imminent. And this is in situations where you are unable to communicate those preferences for yourself. If you were my age or older during the 90s, you may remember the really awful situation in Florida around Terri Schiavo and the battle that actually went all the way to the Supreme Court, from Florida all the way up to the US Supreme Court, around her care, with her parents fighting with her husband over life-sustaining treatment after she was faced with an irreversible condition, and what a drawn-out, heart-wrenching process that was, that really had no good outcome either way, no matter what side or who you really empathize with. Without an advance directive, medical providers may perform life-prolonging treatments such as ventilators or feeding tubes, even if you would have declined them. Family members may be forced to make gut-wrenching decisions about your care without knowing your wishes, potentially leading to guilt or disagreement. So here's an example. You're diagnosed with a terminal illness and lose the ability to communicate. Without a living will, doctors keep you on life support indefinitely, even though you would have preferred to pass peacefully without invasive measures. Imagine what a struggle that would be for your family emotionally, not to mention financially, with prolonged treatments you wouldn't have wanted. I'll mention this. Another added bonus, I guess I'd say, that comes with estate planning is that you do have the opportunity to have these discussions with your family. When we sit down and start to discuss together who you want making these decisions, it often prompts a conversation that you have with family or friends about who you want in these key roles and these key decision-making positions. So while they're discussions that aren't easy to have, it's things that we talk about together and can give you the tools and guidance you need to have those conversations and really make sure that your wishes are known. I think a lot of us can empathize and relate to having family members who are in a situation like this where we weren't able to ask certain questions and had to make decisions about certain treatment or decisions around burial or cremation, or, it's always nice to have additional information when you can. So an advance directive allows you to be as specific as you want around treatment preferences, around end-of-life care. All right, HIPAA authorization. So HIPAA is a law that protects medical records, and an authorization allows named individuals to access them. And by having this document in place, it requires healthcare providers to protect your medical records from disclosure without your authorization. And that's the default. So without this in place, your loved ones, even spouses in some cases, may not be able to access your medical records or speak to your healthcare providers about your condition. This can delay critical decisions or leave your family in the dark about your health status. Imagine this: you're hospitalized and unconscious after a car accident. Without a HIPAA authorization, the hospital refuses to share your condition with a spouse or partner or close family member because they aren't legally authorized. That means that person can't make informed decisions or advocate for you during treatment. The HIPAA authorization itself doesn't give anyone decision-making authority. It just provides the authorization the hospital needs legally to be able to share that information. So it's really important, and because of the penalties involved with HIPAA itself, it gives your providers the security and the comfort that they need to know that you're authorizing the sharing of this information. It's a law that's there to protect us, and that's a good thing. But we want to make sure that the people that you want to have access to that information are clearly stated, and that you make your wishes known ahead of time, and that they can get that information when they need it the most. So without these documents, a financial power of attorney, a medical power of attorney, an advance directive, and a HIPAA authorization, your family may face unnecessary stress, delays, and expenses, and you may lose control over decisions that impact your health, finances, and dignity. These documents ensure your wishes are honored and that the right people are empowered to act on your behalf when you need them most. Finally, in terms of documents, if you don't want to leave your estate plan up to the state and those default rules that we talked about earlier, you have options when it comes to your assets. And the two options that everyone has is to either do a will-based estate plan or a trust-based estate plan. This is a decision that everyone has to make, whether you are married or single, have kids or don't have kids, and regardless of how much money you have. You have to decide if you want a will or a trust. Now, today, the vast majority of our clients and people in the US choose to do a trust instead of a will. And this is something that we discuss more at your one-on-one peace of mind planning session. But let's hit the highlights here and just give you a broad overview. Let's look at a will. So what does a will accomplish? Well, it's better than nothing, right? It's better than dying intestate with those default rules in place. A will is where you can nominate guardians for your minor kids, and you can name beneficiaries for any asset or account held in your name alone. And you can name an executor in your will. This is the person who is in charge of wrapping up your affairs and estate when you are gone. So that's option one, a will. Your second option is to do something called a revocable living trust. And again, that is nowadays the option that most of our clients choose. First, I bet you're thinking, aren't trusts only for rich people? And if you're thinking that, I get it, but respectfully, you would be wrong, because trusts are definitely not just for wealthy people. So what is a trust anyway? Well, simply put, it's an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. That's it. And a few months ago, we did a whole webinar on pros and cons of a will versus a trust. I'm happy to send anybody the recording if you want to email that to me. You can go into a lot more depth, but it's really as simple as that. It's an agreement that spells out the rules. It's a contract, basically. Put another way, it solves all the problems that people assume are solved by a will. And the biggest thing I hear from clients with a will or considering a will is that they want to avoid probate. Well, wills guarantee probate. If you have a will, your executor, your family members will have to go through probate. That's not true with a trust. A trust is outside of probate, and the expenses, the time, and the public nature that comes with probate. So again, this is something that we explore more one-on-one during a peace of mind planning session, but hopefully that gives you a little overview, maybe more information than you started today with. So the next slide after this is that bonus I promised at the top of the webinar here. But if you're ready to gain some control over your future in these uncertain times and protect your loved ones, the next step is to book a peace of mind planning session with us. And that kicks off really the estate planning process. And you can do that by going to gaslaw.click/POMPS or scanning this QR code here. Now, we can do the peace of mind planning session either in person in our office in Dallas or via Zoom. And here's what will happen at your peace of mind planning session. If you're married, both spouses must attend. And we have you fill out a family profile before the session. That gives us some basic info on your family, your background, your assets and loved ones that I look at ahead of time and really tailor the session towards you. That means that we sit down and we can really discuss your goals, and I'm there to answer your questions. And then I present your options. We'll also review our estate planning packages and our flat fees. I think that's really important, because if I was going into this or having a family member talk to an attorney or going to hire someone for any service, I think it's really important to know going in what costs you're looking at. So our estate planning packages and the services we offer are all flat fee. You're not going to get an invoice or a bill for copies for, per hour. You're not going to have to worry each time you send an email or pick up the phone to call us that you're being charged by the minute or by the word. And that's important. And not all attorneys do that. So it's something to be aware of. This is important too. We'll decide if we're a good fit to work together. And that has to go both ways, right? And so we see if we're a good fit. And if so, we take the next steps to move forward. And if not, that's okay too. All right, so here's that bonus I mentioned earlier. And kudos to everyone for sticking with me. Your bonus for hanging in there is that if you book a peace of mind planning session by February 7th, that is next Friday, we'll waive the usual $450 session fee. This is for those of you out there who are ready to cross this off your to-do list here at the beginning of the year and move forward and want to save that $450 by booking by February 7th. If you're not sure, we're not going anywhere. You can book a peace of mind planning session later on, of course, but you won't get that $450 discount. Now, we don't take on a limited number of new clients each month. We are a boutique law firm. It helps us keep our fees down. And it also means that we have to limit the number of clients that we take on each month. So if you want to get your peace of mind planning session on the calendar sooner rather than later, be sure to get one of those slots now and lock in this discount. Finally, if you have any questions at all about the information tonight or anything that you want to follow up on, please feel free to call or email me. Here is my contact information. Get in touch with me directly, and I would be happy to help. I really want to thank you and applaud you for taking the first step tonight just by being here and watching this webinar. I hope it was helpful, and I look forward to seeing all of you soon at your peace of mind planning session. And with that, we have a few minutes left. I'm happy to answer as many questions as possible during the Q&A time. You should be able to click on the Q&A button in the chat and ask a question. Any questions there? So a couple questions that we often get for these webinars, because we are these are available worldwide. One of the questions is if we can help folks outside of Texas, and because I'm only licensed in Texas, I'm only able to help people in the Lone Star State. However, this information should be generally applicable for education purposes nationwide, and we'd be happy to connect you or try to connect you with somebody in your area who may be able to help. So feel free to reach out to us, and if we can connect you with somebody or get the name of somebody who can help you in your area, we're happy to do that as well. Again, happy to take any questions. Please just drop those in the chat here or hit the Q&A icon and type in your question. I want to encourage people to also visit our website at GasperLawPLLC.com. There you will find more resources, including the blog. We have some great blog articles that have various different subjects, but really go into a little more depth than what we can do here and on different points. What I'll also say is that we are in the process of launching a YouTube channel, so please like and subscribe to that, and don't forget to follow us on social media. We have a lot more content there as well. If you have a friend or loved one that didn't get to check this webinar tonight, then you should feel free to share the link with them, and we'll be sending a replay out afterwards. Oh, this is a good question. And this is something that we hear a lot, and about the do-it-yourself websites and the online websites that you can just kind of do it yourself and these documents. So can't you just do this online yourself? Well, you can, and keep in mind that those websites that are out there and the services we provide are two different things, right? So that's why the cost is different. Those fill-in-the-blank websites are just form documents that you fill out and execute yourself. It's not a law firm giving you legal advice. Versus when you come to us or any estate planning attorney, they should be counseling you and giving you legal advice based on your specific circumstances. That means they're going to customize your documents. We're going to customize your documents and make sure that they're signed with the proper formalities and in accordance with state law. We've had clients come in who have previously either gone online and done the do-it-yourself documents, or sadly used attorneys and other attorneys who may be not practicing anymore and provided us copies of the documents that they previously executed. And when I've looked at those, I've sadly seen just recently here issues with the way they were executed. like a will that didn't have the date in the right place, or a medical power of attorney that wasn't notarized properly. All that is, huge issues, as you can imagine, because when the time comes for you to use those documents, they're not going to be valid. So if it's important to you that you get the advice that comes with hiring a specialist, an attorney, customized advice, and that the documents are done right, if those things are important with you, you should work with an attorney. And if not, then there are other options out there. Another good question is, how long does the process take? So we talked about the peace of mind planning session, but what happens after that? Well, our entire process is designed to take about 4 to 6 weeks. After the peace of mind planning session, the next step would be a design meeting, and that's where we sit down and really roll up our sleeves and get into the details about your documents. And from there, we'll send you drafts and a review video to go over everything. And once we hear back from you, we finalize your documents and have the signing ceremony after that here in our office. Or we can do it remotely, depending on if you're in the DFW area or not. I always say at the signing ceremony that champagne is optional, or sparkling cider, but that's always a special day around here because it really is the culmination of a lot of time and energy that you put into making this estate plan come together in peace of mind for your family. But 4 to 6 weeks is about the average, and when we can get things completed for you and with the process. But some of that depends on you. For the peace of mind planning session itself, what information do we need from you? Let's start with what we don't need. And that is, we don't need social security numbers, bank statements, tax returns. We just need a basic understanding and idea of the assets that you own, like your house, retirement account, life insurance, approximately their value, and then how they're titled, if you hold them individually, jointly. And then we'll be asking you some questions about your estate planning preferences, like who would you want raising your minor children? Who would you want in charge of making financial and medical decisions for you, etc. So even if you don't have the answers to those questions right away, we'll have plenty of time to think about it, and we'll walk through those together. Great question about updating your will. How often should I update my will? Broader question in terms of updating estate planning documents, you should update them anytime you have a major life event. And that could be marriage, divorce, children, a death. If you move, especially out of state, you should look at those and update them then. We recommend and offer clients an annual estate plan review. That means once a year, we will sit down either in person or over Zoom, face-to-face, and look things over and talk about not only how your circumstances may have changed over the last year, but let you know if and how any of the laws have changed, because things change, laws change as well. And over the next year, a lot of laws may change. So we want to make sure that your estate plan is a living document and something that grows with you and continues to evolve just as your life grows and evolves. Question about avoiding probate. So more and more we hear probate horror stories, and there are plenty out there. And as I mentioned during the webinar, if you have a will, you're still going to probate. The way to avoid probate is to go with a trust-based estate plan, and then not only to get that trust signed, properly executed in place, but then you have to fund the trust. That means transferring assets into the trust to make sure that the assets that you own, everything that's outside of the trust, is in the trust that needs to be in there, so that those assets avoid probate, and that your family and loved ones don't have to end up opening up a case in probate to transfer those assets and pass on those assets after your death. Well, we're coming to the end of our time here. I again want to thank everyone for their time, for your time, and offer again to be available by phone or email if anyone has questions. And don't forget that Peace of Mind Planning Session, that free offer is out there. It's gaslaw.click/POMPS now through February 7th. Thank you all for attending and have a wonderful night.